Please join me in inviting Honorable Sri Justice P.S. Narasimha Garu, Judge Supreme Court of India, Honorable Sri Justice Anurod Bose Garu, Director of National Judicial Academy and the former Judge of Supreme Court of India, Honorable the Chief Justice of High Court of Andhra Pradesh, Honorable Sri Justice Dheeraj Singh Thakurji, Honorable the Chief Justice of High Court of Jharkhand, Honorable Sri Justice M.S. Ramchandra Rao Garu, Honorable the Chief Justice of High Court of Uttarakhand, Honorable Sri Justice G. Narendra Garu, onto the dais. May I request Srimati K. Radharatnam Garu, 5th Additional District Judge, Visakhapatnam, to present a bouquet to Honorable Sri Justice P.S. Narasimha Garu. May I request Ms. C.K. Gayatri Devi Garu, 2nd Additional District Judge, Visakhapatnam, to present a fresh bouquet to Honorable Sri Justice Anurod Bose Garu. May I request Srimati K. Vani Sri Garu, Judge, Additional Family Court, Visakhapatnam, to present a bouquet to Honorable Sri Justice G. Narendra Garu. May I request G. Anandi Garu, Judge, Special Court for Trial of Offences under POCSO Act, Visakhapatnam, to present a bouquet to Honorable Sri Justice M.S. Ramchandra Rao Garu. May I request Srimati P. Sri Satya Devi Garu, Judge, Special Court for SC and ST PO Act cases, Visakhapatnam, to present a bouquet to Honorable Sri Justice Dheeraj Singh Thakurji. I request the technical team to play Vande Mataram. May I request all the delegates and participants to raise for the national song. Vande Mataram, Vande Mataram, Sujala Sukhala Malaya Shitala Syasyamala Mataram, Vande Mataram, Shubha Jyotsna Pulakitayamini, Pullakusumita Drumadala Shobhini, Suhasini Sumadhura Bhashini, Sukhadam Varadam Mataram, Vande Mataram, Vande Mataram. Ladies and gentlemen, it's our tradition to light a ceremonial lamp at the beginning of any event as an invocation of the prayer Tamaso Ma Jyotirgamai for leading us from darkness to light. May I now invite our esteemed dignitaries on the dais to come forward and light the lamp. We are now pleased to move to the next segment of our program. It's my honor to invite Honorable Sri Justice Dheeraj Singh Thakurji, Honorable the Chief Justice of High Court of Andhra Pradesh, to deliver the welcome address.
Honorable Shri Justice P.S. Narasimha, Judge Supreme Court of India, Honorable Shri Justice Aniruddha Bose, Director, National Judicial Academy, Honorable Shri Justice M.S. Ramachandra Rao, Chief Justice, High Court of Jharkhand, Honorable Shri Justice G. Narendra, Chief Justice of the High Court of Uttarakhand, esteemed colleagues, distinguished members of the judiciary and honored guests, I extend a warm welcome to all of you to this regional conference on court dockets, explosion and exclusion. As we gather here in this vibrant city of Visakhapatnam, also called the City of Destiny, we confront one of the most pressing challenges facing our judicial system, the dual crisis of docket explosion and exclusion. The phrase "justice delayed is justice denied" has become more than a legal maxim. It has become a daily reality that tests the promise of timely justice. Yet, we must acknowledge that the problem before us is not merely about numbers and pendency. It is about human lives caught in the labyrinth of legal proceedings, about dreams deferred, and about faith in the justice system being tested with each passing day. The explosion in our court dockets is not merely a statistical surge. It is a reflection of our society's growing complexity and the increasing awareness of legal rights amongst our citizens. While this awareness is welcome and indeed essential for a vibrant democracy, it presents us with the formidable challenge of managing this surge while ensuring that justice remains accessible to all. Let us pause and reflect. What does this explosion truly tell us? It speaks of a society in transition, of rising expectations, and of growing conflicts that seek resolution through legal means. It tells us that our citizens trust the judiciary to resolve their disputes fairly and justly. This trust is our strength, but it also entails an onerous responsibility. The matter of docket exclusion is equally concerning. When we speak of exclusion, we speak not just of physical or economic barriers to justice, but of invisible walls built by procedural complexities. The solutions we seek must be both innovative and grounded in reality. Today's technology offers promising pathways, from artificial intelligence-aided case management to blockchain-secured record keeping. As the technology evolves exponentially, the ground is shifting beneath our feet. We must adapt and mold our procedures. We must think beyond conventional solutions. Technology isn't just about digitizing existing processes. It's about reimagining what is possible. For instance, the concept of paperless courts is no longer a distant dream. Imagine a system where filing a case is as intuitive as sending an email, yet maintains all procedural safeguards. This transformation is within our reach. Equally important is procedural simplification. Unlearning outdated practices is essential to mastering new ones. Simplifying processes from the format of pleadings to the manner of hearings can have a profound impact. Transformative case management is crucial. This includes taking proactive steps like narrowing issues, setting deadlines, and ensuring cases are resolved within definite timelines. As has been observed by the Apex Court in numerous judgments, procedure is only the handmaiden of justice. We must not let obsolete procedures inflate the docket. Our procedures, while necessary, should not become barriers. As it is often said, there are no inherently protected cases, only cases that unnecessarily are protected by inefficient procedures and management. Further, we must strengthen our alternate dispute resolution mechanisms, not as a secondary option, but as a parallel, equally respected stream of justice delivery. The success of Lok Adalats and mediation centers in India show the potential of these mechanisms. However, the paltry sums which we pay to mediators for either a successful or an unsuccessful mediation do not attract the talent pool that is required to take the burden off the courts. Therefore, we need to have a consensus on the amount that should be paid to mediators with a view to make it financially viable, with the time spent by such mediators on lines similar, if not equal, to the terms of payment to arbitrators. We must also recognize that our judiciary's true measure of success lies not in the number of cases disposed, but in the faith we restore in the judicial system. Every time a citizen walks away from our system feeling heard, understood, and served with justice, we add another brick to the edifice of trust that our democracy rests upon. As we deliberate over the next 2 days, I urge you to think not just as administrators of justice, but as architects of a judicial system that must serve generations to come. We are truly at an inflection point in history. The challenges we face today will seem modest compared to what lies ahead. Our responses must therefore be not immediate, but visionary. The conference ahead of us is not merely about discussing problems. It is about crafting solutions that will shape the future of justice delivery in our country. We are not here to patch the system. We are here to reimagine it. The future of justice delivery isn't in incremental improvements, it's in exponential transformation. We have the intellectual capital in this room to start this transformation. What we need now is the willingness to think differently and the courage to act boldly. Thank you.
Thank you, my Lord Justice, for the warmth with which your Lordship presented the welcome address. Now may I invite Honorable Sri Justice Anirudh Bose Garu, former Judge of Supreme Court of India and the Director of National Judicial Academy, to address the gathering.
Honorable Justice P.S. Narasimha, Judge Supreme Court of India, Chief Justice Dhiraj Singh Thakur, Chief Justice M.S. Ramchandra Rao, Jharkhand, Chief Justice G. Narendra, Uttarakhand, and the Honorable Judges, Judicial Officers, members of the Registry of the AP High Court, and my colleagues from the NJA, National Judicial Academy, as also from the State Judicial Academy of Andhra Pradesh. As a co-host, I welcome you all. Though all the efforts of organizing this program has been undertaken by the Andhra Pradesh High Court, and I extend my thanks, and particularly my special thanks to the Chief Justice Thakur for this program. This year's theme, captioned a bit stylistically, essentially deals with challenges in early disposal of litigations and also ensuring access to justice for those who are unable to approach the court. While we are faced with the daunting and increasing number of filings, well, last year it was 37 lakhs, and the total number of cases which we are to dispose of is about 4.5 crore across the country. It may generate among us and the legal community conditions similar to collective nervous breakdown. But we perk up marginally when we see the number of cases which we have managed to conclude during the same one-year period was 38 lakh cases, which exceeded the number of cases instituted last year. Well, I'm personally no more part of the judiciary, but I am using the pronoun we, as I am tangentially connected with the judicial process still. First, a thought on why so many cases are pending. Here I avoid the usual reference to population-judge ratio, introduction of legislations without undertaking a judicial impact assessment, turning the court, in the words of an ex-Chief Justice of India, into recovery agents for banks, and lack of proper infrastructure. That we shall speak when we are outside, not in a in-house introspective gathering. The judges of India have always been ready to deal with difficult and challenging situations without being, to use a colloquial expression, crybabies. One reason which I think is positive with regard to the increasing number of litigations is the willingness for more and more people to come to courts for redressal of their grievances. Here I agree with Chief Justice. For instance, a water body is being filled up next door, a PIL. A student is unsatisfied with evaluation of his answer script, go to the writ court. In our time, whenever I scored low, my father blamed me, and instead of looking for university's evaluation fault. Now, there is delay in delivery of apartment, claim for compensation. The grievances for which one would not have had thought of coming to court 30 years earlier are now regular visitors to the courts of law. There is another aspect, that is, unlike many developed countries, we have not outpriced the justice delivery system beyond the means of common man or woman. An Irish judge in the 19th century had once said, "Justice is open to all, like the Ritz Hotel." Well, here in India, we have the doors of court open to all, particularly those who go to the tea shops and not a Ritz Hotel. Moreover, we are increasingly relying on technology and possibly have achieved the most in the world in utilizing ICT to further enhance the accessibility of justice. Now, witnesses in support of their claim may not be required to travel to distant court premises, but through electronic means can depose from a location close to his or her residence. We also have a very robust alternative dispute resolution system, which is not only addressing complex multi-million-dollar cases, but also issues like domestic family disputes. On this count, I wholly agree with the Honorable Chief Justice that we have to push mediation more and make it a little, realistically remunerative to encourage the mediators to come forward and undertake the process of mediation. The new economy has also cast a greater degree of responsibility on us. See, at one level, there are legislative injunctions on granting of injunction in respect of infrastructure contracts, as an illustration in the Specific Relief Act. Delay in disposal of a dispute with a foreign firm may compel the nation to pay damages under the bilateral investment treaties. Several cases are pending, I am told, on this count. We have developed commercial courts for giving special passage to business-related disputes for early disposal. In this context, how do we discharge these duties and responsibilities? At one level, as part of our commitment to nation building, we need to fast-track the commercial cases. At the same time, we shall also have to accommodate evicted agricultural tenants, estranged homemakers, dismissed workmen within the formal court system. I am reminded of Justice Krishna. In one of his lectures, he had commented that courts are not like hotel room, that we tell the guest that we are overbooked, you please go to the next hotel. We have to accept and welcome all who come to us, except frivolous litigants. We talk of the glorious days of our judiciary and refer to great judgments of the pre-independence era. However, if you look at the litigant profile, except in criminal cases, it would always be big zamindars, business houses whose causes dominated the boards of different courts. Even in the early days of our Supreme Court, except in the cases involving freedom of speech and personal liberty, the great judgments came from causes brought by big landlords, solvent shareholders, ex-royalties. My object in this address is not to lighten our duties, but to remind us of that the challenge of pendency is surmountable. Here I shall quote a passage on delay. Quote, a judge is not responsible for delay. The number of law courts is few. Where 3 judges are necessary, there is only 1. So conclusion of a case takes time. Moreover, operational laws are very complex. The judicial process involves over-documentation and excessive procedural formalities. Today, the deposition of only 1 witness could be completed because extensive cross-examination by the opponent's counsel. So the rest 5 cases have to be adjourned for a month. Again tomorrow, a litigation that could have been concluded would have to be adjourned because of absence of a non-essential witness, which results in delay. So the next date is given after a month. Unless these formalities are adhered to, the judicial process would not be as per law. The decision would fail in appeal. It has to be admitted that there is delay in judicial process, there is injustice. Now, it may sound familiar and contemporary, but this is a passage loosely translated by me from writing of the 19th century Bengali novelist, Bankim Chandra Chatterjee. We heard Bande Mataram, the creator of that, our national song. This passage was written while describing the plight of the tillers of Bengal. We are dealing with a legacy and now have taken up the challenge of overcoming the centuries-old malaise. I don't think 4 decades back, our predecessors had to get worried about how many cases are pending on the board. There was no system of proper compilation of data. Though the first LAR committee meeting took place in 1926, we are better equipped today due to technology and other aids to deal with this issue. In the course of discussions today and tomorrow, we hope to climb a few steps higher in finding out solution. I don't want to prolong my address. I again welcome all the dignitaries present and honorable resource persons, participants, and hope that there will be wider and vibrant interaction with the participants in the deliberations in the today and tomorrow. Thank you very much.
Thank you, my Lord, for the insights into judiciary which are invaluable. Ladies and gentlemen, I now have the distinct honor and privilege to invite Honorable Sri Justice P.S. Narasimha Garu, Judge, Supreme Court of India, to kindly address this esteemed gathering.
Honorable Justice Aniruddha Bose, as we would affectionately call him Dada when he was there with us in the Supreme Court, Chief Justice Thakur, Chief Justice Narendra, Chief Justice Ramu, as again I would affectionately call him, Honorable Judges of the High Court, District Judiciary, academicians from the Academy. Today is Tyagaraja's Aradhana Day, I was told. And I would say, Endaro Mahanubhavulu, Andariki Vandanamulu. These conferences are really unique for 3 reasons. First and foremostly, we used to have at one time a very vibrant law commission. That law commission was not a statutory body, but it was appointed from time to time. But we had excellent chairman. Even Justice Jagannath Rao was one of those who had reflected on the way law moves on the basis of the statutory law and also on the basis of the law that is laid down by the courts. This reflection was of immense importance to us. Over a period, it's perhaps lost its efficacy, and we have now formulated the Judicial Academy, which seems to have taken the place of Law Commission as it was. Added advantage is that it is a permanent body. It's a body comprising of judges and also academicians and lawyers. What we did is that it has institutional memory because it continues from time to time. It continuously reflects. It has an academic pursuit. Another very important feature is that those who are involved in laying down the law or interpreting laws become part of this Judicial Academy. So its importance cannot be stated anything more than this. Justice Bose is the chairman of it. And we have continuously having regional conferences where stakeholders such as judges and lawyers participate and reflect upon the way the law is moving. The second unique thing about conferences like this are that they are not for general public. They are intended for the real stakeholders who are conducting the proceedings, the judges and lawyers. So the uniqueness lies in the fact that we could reflect frankly, independently, and find out where things are going wrong and how to rectify it. That, according to me, is the real purpose of having conferences such as these. The outcome of this conference in particular must have its reflection when judicial administrators, foremost of it is the Chief Justices, so to say, would go back and apply what is learned here to the disposal of cases from day to day. The third unique feature which thought occurred to me while I was traveling and also strengthened as I was listening to Honorable the Chief Justice and also Justice Bose, is that we have come to a stage where we need to, because of the compelling situations, develop what is called delayed jurisprudence. It's not something which is going to come to an end immediately. Neither this conference nor a couple of other conferences are going to be conferences where a solution could be found, implemented, and then we don't have any delays any further. That won't be the situation. We know the reality of the matter. Till I became a judge, I didn't know how delay was so seriously affecting our lives. I'm saying our because we are part of the system. Two brothers seeking partition of a suit, property, family property, should take 25 years by the time it reaches our court. What happened to the past of the 25 years? How could they not resolve that issue? Matrimonial matters, years together, motor accidents cases. More particularly, I have been seeing in service matters, advertisement challenged, and I am there to sit and decide. An advertisement issued in 2011, and we are in 2024. What is to be done? What kind of a remedy can we give in situations like this? All of you are facing this problem. Time swallows, eats away the remedies that are possible, that people are seeking. When time takes away the first remedy that anybody seeks, what then are the alternatives? Is it merely that is provided you are agreeing with the submission made that there is some kind of an illegality or impropriety in the order passed? How are we to compose, how are we to formulate the remedies because of the long continuous delay? Matrimonial matters, what happened to the life? Of course, that's one-to-one in individual. We didn't decide it. So we treat ourselves as outsiders to a matrimonial problem. But then the 12 to 13 years impasse in their life is contributed by the court. This is the third facet of conferences like this, which we need to reflect upon. Of course, in the next session that is to follow, we will be talking about the docket explosion, exclusion, and inclusion, and other things. This conference, apart from the delays that are caused, is also to discuss facets of ADR, which I am going to speak to you. I share my thoughts when the session begins. The digital divide, which is going to be a very, very big reality, and how we're going to cope with it because we have adopted technology. And then the sensitive aspect relating to media is also an aspect that which we need to deal with it. In the subcommittee relating to having live streaming, we were reflecting on to what extent the live streaming should be made available. There are very many facets of live streaming, the positive and negative facets of it. I'm sure that these discussions will help us understand the problem much better. Then the issue relating to technology, particularly the AI, many of you are now gotten some kind of an expertise in discussing AI issue. We had a professor from Singapore who told us that in times to come, what needs to be protected from AI is our capability and ability to think independently. I initially couldn't follow it, but I realized how true it is. This technologies were always instruments that would aid us do our job better. But then the new technology, artificial intelligence, is a step ahead of that. It's not simply to aid us, but it to substitute us. What happens there is that the only resource for which we are employed here is our capability to analyze, understand, and apply our decision. So it is the decision making of a judge that could be substituted. Technology has this feature of taking over and substituting us, and we get used to it so much. Getting used to a computer, losing the habit of handwriting or losing the habit of dictating to a stenographer, such things become a habit. But then if it becomes a habit that you don't get to think, we don't get to think and delegate the biggest obligation that we have as judges, to delegate the obligation to think, analyze, and apply. It will happen. It will definitely happen, because the number of possibilities that artificial intelligence can think of are phenomenal. It's beyond human mind. They will be able to take 1,000 or 10,000 factors into account and give you a common solution, the best possible solution. And then over a period of time, it's definitely possible that you would begin to believe that that decision is far better than your own decision. It's inevitable. It's inevitable. So that is where the substitution could take place. So these are again aspects that we need to reflect upon. So I congratulate Dada for organizing this South Zone Regional Judicial Conference, and I'm sure every one of us will be benefited by it. Thank you very much.
Thank you, my Lord Justice, for the very inspiring address touching upon the sensitive issues today. As a token of respect, we request my Lords to kindly accept our small mementos. May I request Sri Alapati Giridhar Garu, Principal District Judge Visakhapatnam, to present memento to Honorable Sri Justice P.S. Narasimha Garu, Judge Supreme Court of India. May I now request Sri G. Gopi Garu, Chairman VAT Tribunal, Visakhapatnam, to present memento to Honorable the Director of National Judicial Academy and the former Judge of Supreme Court of India, Honorable Sri Justice Anirudh Bose Garu. I request Sri M. Venkataramana Garu, First Additional District Judge, Visakhapatnam, to present memento to Honorable the Chief Justice of High Court of Jharkhand, Honorable Sri Justice M.S. Ramchandra Rao Garu. May I request Sri U. Prasad Garu, Special Judge for ACB cases, Visakhapatnam, to present memento to Honorable the Chief Justice of High Court of Uttarakhand, Honorable Sri Justice G. Narendra Garu. It's our privilege now to honor Honorable the Chief Justice of High Court of Andhra Pradesh, Honorable Sri Justice Dheeraj Singh Thakurji. May I request Sri C.N. Murthy Garu, Principal Special Judge for CBI cases, Visakhapatnam, to present the memento to His Lordship. Now may I request all the dignitaries and distinguished guests to raise for the national anthem. I request the technical team to play the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Thank you. Before we proceed further, I kindly request all the participant officers and esteemed dignitaries to join for the photo session. May I invite everyone to assemble at the designated area, which is the entrance of this seminar hall, for taking photograph, and we'll be assembling within 10 minutes, by 10:10. Thank you.
We are fortunate to have Chief Justice Rao and Chief Justice Narendra among us. So I'll request, please be present to both of you in the next technical session that will raise the quality of the session. Sure. Thank you.